Now, I'm going to ask a little bit about AI, and that is specifically how is the rise of AI and digital technologies affecting IP protection and management strategies?
Yeah, just in very broad strokes, AI makes things move more and more quickly every day. The speed of everything occurs at an increased rate. There is a lot looked at and analyzed in relation to AI infringing on copyright when the AI is learning and scouring the internet and all the information out there. It's learning based upon copyrighted material, whether that's written words or whether that's photographs or whatever it might be. So there's those concerns there. And it's difficult to detect on a case by case basis whether AI is accessing something that might have a copyright to it and forming a case against AI.
Hi, all. I'm Dr. Donald Wilson, and this is my podcast. Today, we have Michael Sharp, an intellectual property IP lawyer who helps his clients safeguard their innovations towards employing them as a strategic competitive advantage. With a background in science, Mike enjoys science and technology and, of course, the respective field of IP law, engaging with cutting edge developments that keeps his work exciting. Mike, thanks for joining us on my podcast. And why don't we start off with a bit of your professional history from education through your most recent workplace?
Yeah, certainly. So, as you mentioned, my background is in science. That was always a passion of mine: science, technology, innovation, all of those things. And so, I had pursued post secondary education in sciences, in the life sciences. I ultimately did a master's degree in medical genetics, doing research on molecular pathogenesis of certain inherited forms of glaucoma and what was happening there. I found science continued to be interesting. However, it became narrower and narrower as you went along, become more and more specialized. And I was more interested in some of the broader, more practical strokes of commercialization of technology and those types of things. So one route was to pursue a legal education. Within that, there is an ability to work in things like patent law, intellectual property law, where you get to stay in touch with science and technology. And so that's the way I went. I was fortunate to article in Edmonton here following law school at a firm that had a good IP group, learned about patents and trademarks and all the other IP tools, and was there for a dozen years, went in-house and headed up IP group at a publicly traded cannabis company for 5 years, have since returned to a law firm, and now, again, back to working with companies on their IP needs.
And that's a specialized field that you've served in?
Yeah, that's right. That's definitely not something that all lawyers do. It is quite specialized. There's additional certifications that you have to acquire to become a patent agent and a trademark agent, in addition to being a lawyer. So it is something that you do continually learn and pursue after law school.
Well, let's just jump right in then on some of the basics having to do with IP. Some of our viewers would look to this to be their introduction towards understanding intellectual property. So, how would you define intellectual property in the context of innovation? What are the key forms of IP that innovators should focus on?
Yeah, so intellectual property are legal rights around intangible assets. So that's one way to look at it. It's a legal tool that you can commercialize and help leverage your innovation, your R&D as part of your company. Particularly on the innovation end, some of the IP tools are patents, trade secrets, and whatnot. There are other forms of IP, include trademarks and copyright, that may or may not apply to the case an innovative company. The trademarks will relate to branding. Copyright could relate to software and manuals and materials and things like that. But often it's this balance between patents protecting inventions and trade secrets protecting other technical know-how that are really the two big ones in innovation.
And then, why is IP critical in today's innovation driven economy?
Yeah, everything is so much more and more competitive, right? So it's an additional level of sophistication that either an innovator or a company can have that helps shape the business case around what they're doing. A common theme and something that's the bottom line, I feel, all the time, you have to ask yourself is what's preventing others from doing what I'm doing now? If I have a great idea and I want to move to the next step, that's great. But once I launch something or once I release something, what's preventing others from just jumping on it, doing it better, having more resources, or selling knockoffs and things like that. So it is really critical to know your ability to use IP rights to protect yourself and prevent others from doing what you've done and what you've created.
Okay. And we really start to the idea of patents. If any of the viewers are coming up with a better mousetrap and they want to jump into a patent to try to protect that IP that they've just developed, are there high costs associated with that?
Yeah, it's a good question. And sometimes there's some misconceptions or some misunderstandings around. There certainly are costs, but one extreme example, what I hear is that small companies will say, I don't have millions of dollars to enforce a patent. Why even bother starting? And really, that's a bit of a fallacy. There's incremental costs and steps along the way. And
Yeah.
enforcement's not always the end result. It might be licensing or sale. You might have an exit of your company being acquired, something like that. So the costs on the front end can be, again, not nothing, but could be as low as $5,000 or something like that to put together a quick and dirty provisional application to file and get that started. And you would work with that in parallel as you continue to perform your IRD, refine your prototype, those types of things.
I seem to remember seeing along the way in my career several of the products that I would come across with a designation of patent pending. What does that mean exactly?
Yeah, absolutely. So that means that a patent application has been filed. It doesn't mean that it's necessarily been reviewed by the patent office or approved or issued. So without an issued patent, you're not able to commence a lawsuit against someone for infringement. But this patent pending status still has some power of deterring competitors from entering it because they assume you're going to proceed with the steps to get the patent issued. And certainly you're able to license those rights if you need to. You can point to a filed application and say, this is what my invention is. It's just going through the process, but we can license this and commercialize this as we go along.
Okay, good. Shows that somebody is in the process and maybe scares off those competitors who are trying to copy that IP. About collaborative environments. We talk about a bit of this in one of my classes. What unique challenges do collaborative environments, partnerships, joint ventures, etc., pose for IP protection?
Yeah, it's interesting. I'm dealing with one of these right now. And one of the biggest challenges is that you have multiple cooks in the kitchen. Interests aren't always aligned. You might have multiple inventors. They might have multiple employers. So the IP at the end of the day could be co-owned, and one organization might want to head it in one direction. The other organization might not. And it leads to some issues. And so it's best handled up front if you can while you're contemplating this type of collaboration. You have those early discussions under a non-disclosure agreement. So an NDA is quite common so that you can exchange confidential information, talk about the project, but then also iron out some of these critical terms. Who's going to own the IP? Who's going to pay for IP costs? Who's going to have input on how we navigate the scope of the monopoly? Who's going to be obligated to monitor infringers? All these types of things, because even if people are aligned early on, things change, directions for businesses change, inventors' priorities change. And to have some sort of research agreement on the front end or a manufacturing agreement or whatever it might be is really helpful to help guide things moving forward. And instead of having to reinvent the wheel every time and sometimes never having alignment, and then you're stalled and can't pursue any protection at all.
Yeah, I'm taken to a place where I envision the types of people who are responsible for clamping down on those types of agreements, and then the types of people who are actually doing the developing. And sometimes those personalities are not exactly the same. The sort of detailed level that you're getting to in agreements might not be the first thing that comes across those with the scientific minds.
Yeah, absolutely. People are excited to get into the project and do the research and come up with something exciting. Commercialization is often downstream. You may end up with $1 billion idea, and then maybe the fighting starts then. So try to organize stuff on the front end. And
Yeah. Interesting. The types of legal agreements that I'm familiar with, like non-disclosure agreements, joint development agreements, which are just the overarching sort of agreements that I think we're talking about right now, are those types which are the most important. I hear you saying it's the joint development agreements that probably make the most sense to detail those sorts of items through.
That's right. Yeah, that's where a lot of those provisions would be. Usually the NDA is upstream of that development agreement. So you could have a conversation about what you're bringing to the table, what they're bringing to the table, what the ideas might be. So I do think an NDA is critical. But once you get to the collaboration itself, the confidentiality provisions that would be in the NDA would also be in the joint research as well. So it can be incorporated there.
Now, all of this can end up in a dispute between parties. And when a dispute over collaboratively created IP emerges, what's the format? Where is the resolution of this ownership? Where does it take place?
Yeah, ultimately the courts if it has to. And so that's the last resort. That's not an ideal situation for anyone is to have to take something all the way to trial. Again, best practice would to be try to deal with the ownership issues up front. Failing that, have some ongoing conversations about where everybody stands. And ultimately, there may be possibilities of using, instead of the court system, an alternative dispute resolution system like a mediator, like an arbitrator, these types of things where, unlike the court system, you can keep the subject matter quite confidential. Not all the documents have to go into the public domain, and you can have a privately agreed mediator to go through the process. Having said that, usually it's quite clear. Inventorship is usually quite clear, and an ownership flows from inventorship, whether it's the individual or the employer of the inventor. In most cases I see, it's quite clear where maybe there's a party who thinks that they should be an owner, but if they're not an inventor or they don't employ one of the inventors, then it's quite clear that they're not going to be an owner.
Have you ever come across a situation where, let's say, a person invents something and then they make a record of it, and then someone else comes up with the exact same idea and they patent it, and so there is a dispute over whose ownership it really is?
Yeah, it's rare. It can happen. I found cases where very similar inventions have been designed or created around the same time. And then it's a race to the patent office. And so almost universally around the world, now it's based on a first to file system. So you could have said, I invented this 10 years ago, and you invented your version only last year. It's who filed the patent application first. And this is the priority. So the US used to have a separate system where you could have these disputes on first to invent, but that's no longer the case. It's always first to file.
So let's move on to the risks and opportunities. What are the biggest risks companies face regarding IP theft or infringement, and how can they mitigate the risks?
Yeah, it might be surprising, but truly it's internal threats. It's employees, former employees, taking knowledge with them and moving on. Sometimes it's as bad as, like you say, it could be framed as theft, where people are taking laptops or hard drives with confidential information and moving on. So these will be some of the people closest to the project, some of the people most passionate about it. And it's very important to have those safeguards in place up front when everybody's getting along and there's a standard employer-employee relationship. You can have that agreement in place where it's clear that the IP created is owned by the employer and that the employee has an opportunity to disclose, well, I was working on these 4 projects before I started. They're separate. The employer shouldn't have any part of those. And you can have that incorporated into an employment agreement if you like. So there's those legal mechanisms, but there's also practical mechanisms, keeping your R&D under lock and key, whether that's digital lock and key or physical lock and key, and only allowing people access to information on a need to know basis in a lot of ways as well. So it inhibits the free collaboration a little bit, but at the same time, the business assets are a bit more secure.
Interesting. I'm sure there are a lot of scientists that have their own projects and move from company to company. So I can see where that would be a particularly prudent move to declare all of your IP up front.
Absolutely. Yep.
Now, I'm going to ask a little bit about AI, and that is specifically, how is the rise of AI and digital technologies affecting IP protection and management strategies?
Yeah, just in very broad strokes, AI makes things move more and more quickly every day. The speed of everything occurs at an increased rate. There is a lot looked at and analyzed in relation to AI infringing on copyright when the AI is learning and scouring the internet and all the information out there. It's learning based upon copyrighted material, whether that's written words or whether that's photographs or whatever it might be. So there's those concerns there. And it's difficult to detect on a case by case basis whether AI is accessing something that might have a copyright to it and forming a case against AI. So that's one sort of concern. But on the flip side, what AI can do is it can be a new tool for monitoring infringement. So in another context, you can use AI to your advantage and you can automate looking at Amazon, looking at other sites for potentially infringing devices or photographs or whatever it might be. And then the manual component comes out of that. And again, it can move much more quickly and it can be to your advantage.
Yeah, I'm seeing a whole bag of questions coming out of that one, but I'll try to center in on one that is specific to generation of IP using AI. And let's say, as a case, I were to create a new product or service or something using AI to augment my ideas, where my ideas were just prompts. And I took that AI and then patented it. Are there any bumps in the road there? What do I have to look out for as I use large language models, for instance, Chat 4.0 and so forth, to create what I am attempting in intellectual property?
Yeah, it is interesting. There have been a few case studies about examining if AI itself could be a creator or an inventor. So could it be an inventor on a patent application? Could it be an author on a copyright registration or application? And around the world so far, the case is that the offices have been saying, no, we look at the framework and it has to be a human inventor, human author, and a human owner. Sorry, not a human owner in the sense that businesses can be the owners, but the creativity and the inventiveness always stems from a human being. And they made analogies to animals developing things or creating things. We can talk about Lucy the elephant and her paintings, or we can talk about other aspects and the offices and courts around the world that consistently come back to say this should be a human creator and author. So all I would say in your situation is you're free to use it as a tool. It could be analogous to using a word processor. And there's a lot of discussion on whether the creativity is in those prompts, the iterations, the modifications, or is it like you throw something to the wall and it sticks? And really AI is are they just doing routine trial and error, or are they doing the creative aspect? And so far, it's more thinking in the former, where the human is still more involved than the AI.
Yeah, that's interesting because on the scholarly side, we've pretty much taken an easy out by saying if you were providing large language model replies within any publication and you're not identifying how it got there, you're essentially plagiarizing. So that's an easy one. That's an easy one to get out of. But I can see how as AI progresses and suddenly becomes in some ways equivalent to what humans can do for creativity, things will start to change. They'll converge into something that I think will be more easily defined as almost human creativity.
Yeah, it's going to be very interesting to watch.
So advice for students and innovators, early stage startups, what advice would you give to a startup or an innovator just beginning to think about IP protection?
Sure. You know what? I guess the one thing I would say first is that intellectual property shouldn't be an intimidating conversation or topic. I think that I only really learned about IP when I was in grad school. It's not something I knew about growing up or anything like that. I just learned as a researcher, and it should be something that's getting more and more accessible. There's a lot of good educational materials around IP. I think that people should feel free to read and learn on their own. Always verify what they're absorbing and see if it's the case or not the case, but get the general principles down. And so that's one aspect. And then the other aspect is really almost secrecy, and keeping your ideas to yourself is important, both in the patent route and the trade secret route, because a public disclosure without an NDA, for example, so not any disclosure, but a disclosure that's public, that can start the clock ticking on your patent application timeline, and it might sail without you knowing. And it might lose the ability to keep it as a trade secret forever. And so you keep things close to your vest, even if you want to convey to some groups about the potential of what you're creating. You do that under an NDA, or you always keep the secret sauce, the real details or the black box confidential, and you're not open about that part.
It reminds me of the adage, loose lips sink ships.
Absolutely.
Interesting. And then what do you believe is the most often overlooked point in IP education for students and young professionals?
Yeah, I just wish it was integrated more into all sorts of streams of education, whether it's technical education, business education, or otherwise. We're talking about innovation today, but on the creative end, even if for artists, if there was more education, whether it's music or painting or sculpting or whatever it might be, having an introduction to intellectual property is important. I do think for students, one thing that would be good to know is your rights, maybe as an employee. So what we talked about before about starting a job, and are you assigning your IP rights over? Can I be clear about what I've brought to the table or I'm continuing working on outside of the scope of my employment? I think that would be a great topic for people to learn early on so that they are confident continuing with their side projects and continuing to innovate, even if it's not their day job.
Good advice. Finally, emerging trends. And this is the hot topic. What trends do you see in IP law and management over the next decade?
Yeah, of course, the AI aspect is very interesting, and there'll be other forms of automation as well. I do think that in Canada, we've been playing catch up on some international standards in the IP regimes, and we're getting close to where we are harmonizing with other countries and other systems. So that's important. But I do think that globalization continues to be a big part. We want Canadian companies and Canadian innovators to be able to access market confidently with their IP protection in hand for that jurisdiction. Because just because you have protection in Canada doesn't mean you have protection elsewhere. It's country by country. And so I hope that harmonization just makes things easier and easier for companies.
Okay. And any countries to stay away from?
Not necessarily. As an anecdote, I can say that a lot of companies dropped any Russian applications when they invaded the Ukraine, and they were concerned about putting money into a patent office where the fund might be diverted to a war effort. So that's an anecdote from a few years ago. Otherwise, some patent offices are more well respected than others. And then you also look at the enforcement ability beyond that. How will a court view these assets, and are they enforceable against infringers and counterfeiters? So there's still uncertainty, but even in my career, I've seen countries improve a lot on their IP systems.
Thanks for that, Mike. And this brings us to a close. I've really enjoyed our discussion here, Mike. Thanks for the IP information. I know you're a busy guy, and taking this amount of time away from your day gig is probably difficult and certainly appreciated by me and my viewers.
Thanks for having me. Happy to discuss IP anytime.
All right. Thanks, Mike.